All these cases sent to the Illinois Supreme Court for review. All these denials. You can count the allowed cases on one hand, but there's one particular denial that could be a game changer. When people do the most, I do the analysis. Let's go. Today we need to talk about some major legal developments with the Illinois court that could connect to the Quadajah Johnson case, and in a very important way. I'm discussing this today because a lot of people are under the impression that if the Illinois Supreme Court denies the state prosecutor's PLA, then that automatically means the appellate court decision stands and Quadajah Johnson gets to go home on pretrial release. But that's not necessarily true. And I'm not implying that the state's PLA will be denied, but I discussed in an earlier video that the likelihood of the case being allowed is very slim. Now, just hear me out because I was scouring through some of the more recent Illinois Supreme Court decisions, and let me tell you this. In March of 2026 alone, the U.S. Supreme Court denied almost all of the PLAs they received. That's right. Out of 137 cases, the Illinois Supreme Court only approved 3 cases. You can count them on one hand. We still don't know what the final outcome's going to be. They just agreed to review those 3 cases. And I want to talk very briefly about those 3 approvals just to show y'all the type of cases that this Supreme Court deems worthy of their attention. First up is the Luskin-Kershin case. The case involves a medical malpractice and wrongful death lawsuit filed by Andrew Luskin-Kershin after his father, William Luskin-Kershin, died following treatment at OSF Healthcare Systems Hospital in Rockford, Illinois. The lawsuit alleges that anesthesia providers and hospital staff negligently injured William during surgery, leading to complications and ultimately his death. But the issue that reached the Illinois appellate courts and now won the attention of the Illinois Supreme Court was not whether malpractice occurred. The dispute was over whether the lawsuit should be heard in Cook County or transferred to Winnebago County, where the treatment actually occurred. So the Illinois Supreme Court has agreed to hear the Luskin-Kershin versus OSF Healthcare System case. The appellate court ruled that the case belonged in Winnebago County because nearly all the witnesses, the records, and the events were located there. By accepting the PLA, the Illinois Supreme Court has signaled that it may want to clarify state rules on venue transfers, judicial discretion, and just how far plaintiffs can go in choosing where to file lawsuits. And next, there's the Lanning case. The Illinois Supreme Court has agreed to hear the appeal in People versus Daniel W. Lanning, a case involving a former children's home employee who was convicted of and pled guilty to essay of a 14-year-old minor. Lanning was sentenced to 22 years in prison. The court appears interested in not so much the criminal act itself, but a larger legal question. And that's whether the trial judge improperly used factors at sentencing that were already built into the criminal charge itself. And they sometimes call that double enhancement. And now, since the Illinois Supreme Court accepts very few PLAs, the decision to hear this case suggests that the justices believe the issue could impact sentencing law statewide. And then there's the Calvin Doss case. The Illinois Supreme Court agreed to hear the appeal in People versus Calvin Doss, a major sign that the justices believe this case raises important statewide legal questions. The case centers on self-defense, domestic violence awareness, and whether Doss should have been convicted of first-degree murder or second-degree murder. based on an alleged fear for his life. Now, mind you, this case is about a trial conviction, not about pretrial release. I just want to make that clear, but let's continue. According to the appellate decision, Calvin Doss was convicted of first-degree murder after shooting and killing Vanessa Thomas, who was his girlfriend and the mother of his child. And this happened back in April of 2020. Doss admitted to the shooting, but he claimed that he acted in self-defense. He was sentenced to 50 years in prison. At trial, several major disputes were noticed, and that was in the evidence. The state was allowed to introduce evidence of a prior domestic violence incident involving Doss and Thomas under the Illinois Domestic Violence Propensity Statute. Then Doss wanted to introduce additional evidence that his girlfriend/baby mama had violent tendencies and had threatened other people. Now, some of that evidence was admitted, but other portions were excluded. So Doss argued that the state failed to disprove self-defense beyond a reasonable doubt. He argued that the conviction should have been reduced from first degree down to second degree murder because he genuinely feared for his life, even if that fear was unreasonable. And by accepting this case, the Illinois Supreme Court could actually clarify how much evidence defendants can use to show a victim's violent history, and when imperfect self-defense should reduce a major charge in Illinois. But there's another Illinois case I want to highlight, and that's the People versus White. We should pay close attention to this case because this is where things get really interesting. In People versus White, the Illinois Supreme Court officially denied the PLA. So technically, the court refused to fully take the case for review, but then they turned around in that very same order, and the court did something extremely important. The justices used what's called their supervisory authority, and they used it to direct the appellate court to vacate its prior judgment and reconsider the case in light of newer Illinois Supreme Court ruling called People versus Spencer. Now let that sink in for a minute. The Supreme Court denied the appeal, but still intervened. That means that a PLA denial doesn't always mean that it's over and nothing else can happen. Instead, the court can still step in indirectly if the justices believe this, that the appellate court may have applied the law incorrectly, that a newer Supreme Court ruling changes the legal analysis, or that the case has broader statewide consequences. And that is where the Quadajah Johnson case becomes relevant. Because the prosecution is arguing that the appellate court made a decision to release Quadajah Johnson on pretrial release based on self-defense, which hasn't been proven or disproved yet because the case hadn't even gone to trial. But concluding that Quadajah Johnson killed Romika Blackman in self-defense would deem her not dangerous. And why is that? Because self-defense is not murder. Self-defense is a justified use of deadly force. But also, Quadajah Johnson's case is not just about one defendant anymore. The case has become part of a much larger conversation involving the Pretrial Fairness Act, judicial discretion, public safety concerns, detention standards, and how appellate courts across Illinois are interpreting these laws. So even if the Illinois Supreme Court denies the state prosecutor's PLA in Quadajah Johnson's case, the court could theoretically still issue guidance. They can order reconsideration of the appellate court ruling. They can vacate part of the ruling, especially the part that says the defense proved clear and convincing evidence of self-defense. Or the Illinois Supreme Court can direct the lower court to reevaluate the case under new precedent. And now I'm not saying that will happen, but what People versus White proves is that the Illinois Supreme Court absolutely has the authority to do so. And to be honest, this really does matter a lot because a lot of people only focus on whether a PLA is allowed or denied. The real story is sometimes hidden inside the language of the court's disposition. The Illinois Supreme Court doesn't always operate in dramatic TV style where they fully take over a case with oral argument or those lengthy hearings. Sometimes the court will make a more narrow procedural move. They'll do it behind the scenes, and that can still completely reshape the legal outcome. And in my opinion, that's exactly why people following the Quadajah Johnson case should pay very close attention to whatever wording comes out of the Illinois Supreme Court, especially if the state's PLA gets denied, because a denial alone may not tell the entire story. And if the justices believe that this appellate ruling could affect courts statewide or even create confusion about detention law under the Pretrial Fairness Act, they could still decide that some level of intervention is necessary. And that's why I keep saying Quadajah Johnson's case may end up having implications far beyond Quadajah Johnson herself. But now I want to hear from you. Do you think the Illinois Supreme Court is going to allow the case to be heard? Will they deny the PLA completely? Or will they deny the PLA but use supervisory authority like they did in People v. White? Right now, Quadajah Johnson's case is still moving full steam ahead, but the decision on releasing her from jail during pretrial is very much on pause. If you enjoyed this video, please give it a thumbs up and share it with someone who can use this message. Subscribe to the channel if you haven't already done so, and leave a comment down below letting me know your thoughts. What do you think Quadajah Johnson's fate is regarding this PLA? Meet me in the comments. We can continue the conversation there.